The Senate Subcommittee on Ethical Conduct will come to order. Today is Monday, May 5th at 9 a.m. Welcome, everyone. Hope you all had a great weekend. Members, on today's agenda are two items to take action on. First, we'll be taking a vote on the advisory opinion resulting from Senator Champion's Senate Rule 55.2 request. As a reminder, at the end of our April 24th hearing, the subcommittee ruled that there was a finding of no financial conflict of interest on the introduction of Senate Bill 2978 in this legislative session. The subcommittee did not make any findings related to the introduction of Senate Bill 7970 in the 2023 legislative session. The subcommittee recommended that Senator Champion disclose any appearance of a potential conflict of interest to the committees of interest when he is the chief author of bills. The advisory opinion on today's schedule contains the recommendations of the subcommittee in analyzing both these matters. The second item on our agenda is the ethics complaint brought by Senator Kroon and others against Senator Champion on April 10th. Members of the audience, I'd like to take this time to ask that you silence your phones. And throughout today's proceedings, please, we expect the audience to refrain from clapping or audibly reacting to any actions taken by the subcommittee. Thank you. Members, you've all received copies of the Senate Rule 55.2 advisory opinion in your committee packets. This draft should reflect any changes that were requested in the early drafting of the opinion, which you were able to provide feedback on over the last week. I'll ask Ms. Stengel to provide a summary of the advisory opinion, then we will vote to adopt it. Ms. Stengel.
Thank you, Madam Chair. Briefly, the first portion of the advisory opinion gives a brief summary of the meeting dates and times and an overview of the opinion. There is a brief listing of the facts with a link to the Senate archives where you can access all of the materials submitted by Senator Champion. There are on page 2 some additional details about the Senate files in question. On the bottom of page 2, an outline of Minnesota Statute 10A07 and the relevant Senate statutes. And on page 3, there's a brief summary of the opinion and recommendations, both directly the recommendations to Senator Champion and the subcommittee's thoughts about to the legislature as a whole to think about disclosure of conflicts of interest.
Are there any questions from members of the committee? I just wanted to make one brief comment that I continue to share some concerns about the definition of an appearance of a potential conflict of interest. And because I think that this opinion will now apply to the entire legislature. So it can be a slippery slope, members. But with that, any other comments or questions from members of the committee? Then Senator Miller.
Madam Chair, I'd like to move adoption of the advisory opinion.
Senator Miller moves that the advisory opinion dated May 5th, 2025 be adopted. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. Next, we will move to the matter of the complaint dated April 10th. I'll start with an outline of the procedure the subcommittee will follow today. Before we begin with the presentation of the complaint, I will place everyone who will provide testimony under oath. The complainants listed as Senator Kroon, Green, Utke, Wesenberg, Lucero, and Drazkowski. Oh, wait, I have to do the oath first. Nope, not yet? Okay. The complainants will have 15 minutes to present the complaint. The complainants may divide the time however they would like. The complainants will be allowed to make the presentation without interruption. After the complainants have completed their presentation, there'll be an opportunity for the subcommittee to ask questions of the complainants. Any member of the subcommittee may ask questions. Senator Champion or his attorneys, Mr. Charlie Nowen and Mr. David Zoll, may also ask the complainants questions. Then Senator Champion or his legal representative will have 15 minutes to present a defense against the complaint. They will be allowed to make the presentation without interruption. After Senator Champion or his attorney have completed their presentation, there will be an opportunity to ask him questions. Any member of the subcommittee may ask questions. The complainants may also ask questions of Senator Champion or his attorneys. Then we will move to closing statements. The complainants will have 5 minutes of uninterrupted time to make the complainants only, to make a closing statement. We will not be taking public testimony. After testimony is completed, the subcommittee will deliberate next steps. Under Senate Rule 55.5, this is a probable cause hearing, and the subcommittee has 3 options before it. Make a finding of no probable cause, which concludes the matter. Defer action until a certain date or time, or proceed with this investigation. For purposes of this proceeding, probable cause should be understood as comparable to the legal standard that means there's a reasonable grounds to believe that the conduct in question has occurred or that a violation of ethical conduct has occurred. We will not be taking any action if all 4 members of the subcommittee are not present. That means if anyone needs to step away from the room at any point, please let me know and we'll take a brief recess. Are there any questions on the procedure before we begin? All right, those who plan to testify now, please come to the testifiers table so I can administer the oath. You do swear that the evidence you shall give relative to the cause now under consideration shall be the whole truth and nothing but the truth.
I do.
And this you do affirm under the penalties of perjury.
I do.
All right. All right, thank you. That's where they say the I do. Now we'll ask Senator Kroon to make the presentation of his complaint, and you have 15 minutes, Senator Kroon.
Thank you, Madam Chair, members of the Subcommittee on Ethical Conduct. Thank you for taking the time today to review this complaint. I know it's a busy time of the year for us all, and your thoughtful consideration of this matter is appreciated. I'm here today speaking on behalf of myself and my co-signers of this ethics complaint because we believe the actions of Senator Bobby Joe Champion failed to meet the Senate's high standards of conduct, specifically Senate Rules 56.1 and 56.3, as well as the Code of Ethics Rule 1.30, as outlined in the Minnesota Senate Policies for Senators and Staff. This committee has recently discussed Senator Champion's actions as it pertains to Senate Rule 56.4, so we'll move quickly over what are agreed upon facts. We are expressly concerned with Senator Champion's actions in being the chief author of 2 appropriation bills, Senate Files 2970 and 3035, both in 2023, and Senate File 2978 in 2025. Contained in each of these bills was an appropriation to Community Action Partnership of Hennepin County to be directed in part to 21 Days of Peace, a project of Salem, Inc., which was a legal client of Senator Champion. Senator Champion's decision to sponsor Senate File 2970, a legislator-directed appropriation, sometimes called an earmark, and included in his Jobs Omnibus Appropriation Bill, resulted in his legal client obtaining $3 million in public funds. We believe it is a violation of Senate Rules 56.1 and 56.3 for Senator Champion to have carried this legislation for a legal client, particularly without disclosing the relationship to his colleagues in the Senate or to the public. Because this committee has already opined on Senate File 2978 in 2025, I'll focus most of my comments on the bills introduced in 2023, which resulted in that $3 million appropriation. As chief author, Senator Champion introduced Senate File 2970 on March 16, 2023. As chair of the Jobs Committee, Senator Champion gave his bill a hearing in the Jobs Committee on March 20th, 2023. Also, as chair of the Jobs Committee, Senator Champion was responsible for including his bill in his final jobs appropriation package in 2023, which was Senate File 3035. He spoke in glowing terms about the work of 21 Days of Peace and brought Reverend Jerry McAfee with him to testify on behalf of the bill. At no point during the bill presentation did Senator Champion acknowledge the legal work he did for Salem, Inc. In fact, he did not disclose a relationship any more extensive than that of a senator doing good constituent work supporting a group in his community. However, Senator Champion wasn't just a senator supporting a group in his community. He was the attorney of record for that group when he introduced the bill and when he presented the bill to the Jobs Committee. He was supporting a group where he was their lawyer in a series of mortgage foreclosure lawsuits involving the group's financial matters. As this committee heard a few weeks ago, Senator Champion represented Salem, Inc. in a dispute where Salem, Inc. was having multiple of its properties foreclosed. The lawsuits were started in 2022 and ended on different dates in 2023. According to online court records, judges approved the final settlement on different dates for each lawsuit. One was on February 8th, 2023, one on February 21, 2023, and one on April 18th, 2023. Of note, this last date is after Senator Champion presented Senate File 2970 to the Jobs Committee. Therefore, there can be no question he was the attorney of record for Salem, Inc. when he introduced the bill and when he presented it to the Jobs Committee. But even if Salem, Inc. was a former client and not a current client when he introduced the bill and presented it to the Jobs Committee, Senator Champion's role as a lawyer still conflicted with his role as a senator when it came to Salem, Inc. Lawyers have a unique position in the legal process that carries with it significant responsibilities. They are governed by the lawyer's professional rules of conduct, and lawyers are to serve as advocates for their clients, as well as provide guidance and counsel on how to navigate complicated legal matters. Being a lawyer requires you to look out for the best interests of your client, and it creates obligations, some of which continue even after a legal case has concluded. Being a lawyer in Minnesota also brings with it a commitment to provide pro bono work. The professional rules of conduct makes no distinction on the commitment a lawyer makes to their client, whether they are paying clients or receiving pro bono representation. Regardless of compensation, an attorney-client relationship is a privileged relationship that brings with certain duties and responsibilities to your client. Some of these obligations exist even after the legal issue under representation has been resolved. And those obligations include a prohibition of using information relating to the representation of the former client to the detriment of that client. Moreover, attorney-client privileged communications remain privileged even after a lawyer is no longer representing the client. This is where we contend Senator Champion's actions violate Senate rules. Senate rules that require senators to adhere to the highest standards of ethical conduct and defines improper conduct as that which violates the norms of Senate behavior, betrays the public trust, or brings the Senate into dishonor or disrepute. Our code of ethics that tells us to avoid actions that might impair your independence of judgment or give the appearance of impropriety. With the responsibilities Senator Champion owed to Salem, Inc. as their lawyer, how could he have testified in an honest, unbiased, and neutral manner to the Minnesota Senate? How could his independence of judgment not be impaired? He was their lawyer. He had a duty to zealously advocate for his client, and even after the legal representation concluded, he had an ethical duty not to share anything he knew about those lawsuits that might adversely affect his client, Salem, Inc. For example, would the Jobs Committee members have found it relevant that Salem, Inc. had recently been taken to court in numerous cases for failing to pay back loans and where multiple foreclosure actions had been commenced against them? I know I would have been. Would members of the Senate have expressed concern about taxpayer dollars going to a group that may have been struggling to pay its bills? I know I would have been, and I'm sure many other members would have been as well. We don't know exactly what would have happened if that information had been shared with members because Senator Champion failed to disclose this information to the committee or to the Senate as a whole. Senator Champion vouched for Salem Inc.'s good work, and his colleagues respected him enough to accept that judgment. This committee considered Senator Champion's actions in this case under an advisory opinion. And while you agreed there was no violation of Senate Rule 56.4 because he was not paid for his legal services, you made no opinion on Senate Rules 56.1 and 56.3. Moreover, you did recommend Senator Champion disclose any appearance of conflict of interest in the future when he is the chief author of bills. Here we have a concrete case where he did not disclose an appearance of a conflict of interest on a bill that he chief authored. While disclosure was certainly required in this case, it is questionable, however, if disclosure alone would have been enough, which shows the seriousness of this matter. If Senator Champion had disclosed to the Jobs Committee that he had recently represented Salem Inc. in court and was their attorney of record at the time, it would have been a more complete picture. However, Senator Champion's obligations to Salem as its lawyer still would have remained in conflict with his role as a senator. Sharing that he had represented Salem likely would have brought the next question: what did you represent them on? If other members knew Salem Inc. had recently been sued for failing to pay its bills, it may have made it less likely for them to have received a legislative appropriation of $3 million. It would have been a more truthful testimony as a senator, but it still would likely have adversely affected his client. There was no clear path for Senator Champion to be both fully transparent about his relationship with Salem Inc. without coming into conflict with his professional responsibilities to Salem Inc. When a professional attorney-client relationship is placed into conflict with the responsibilities of serving the public as a member of the Senate, a senator has violated the public trust. I'm not going to judge whether Salem Inc. does effective and good work. That is not the issue today. But it does appear that we, as legislators, did not have all of the relevant information to make an informed decision on whether Salem Inc. was deserving of $3 million of public funds. And Senator Champion, as the chief author and their lawyer, was in the best position to know that information, but he was in no position to disclose that information because of his professional obligations to his client. The issue today is whether Senator Champion's attorney-client relationship with Salem Inc. created a situation where the public trust in the institution of the Senate was betrayed. Due to the relationship Salem Inc. had with Senator Champion, it is difficult for the public to have faith that the projects selected by the legislature for public funds are being chosen based on merit. I would point this committee to the advisory opinion issued to Senator Satvir Shadhari in June of 2010. While different circumstances, there is some overlap. Like in Senator Champion's case, Senator Shadhari did not have a personal financial stake in the legislation at issue. However, the Ethics Committee at that time still admonished Senator Shadhari in a written opinion, noting, quote, "Senators should at all times conduct their legislative actions in an open, honest, and forthright manner, especially when they may be perceived to have a financial or personal interest," unquote. And, quote, "A senator is expected to speak truthfully when describing a proposed amendment, who wants it, who supports it, and who is opposed to it. When you told the members of the conference committee the amendment had been added by the House, you should have disclosed your role in suggesting the amendment to Representative Dill," unquote. This advisory opinion makes it clear it's not just about what you say, but also about what you don't say. Speaking truthfully requires an affirmative disclosure of the facts necessary to provide a complete picture. Like Senator Shadhari's actions, Senator Champion's conduct did not bring him financial benefit, but Senator Champion's failure to be completely honest with his colleagues about his relationship with Salem Inc. served to damage public confidence in the institution of the Senate. It harms the Senate when the public is given more fodder to believe politicians are only out to help themselves or their friends. The public trust is not something we should take for granted. Minnesotans voted for us to help them with their lives, not to enrich ourselves or our friends. The public struggles enough to have confidence that politicians of both parties are truly looking out for them, and we should operate in ways to restore trust in the Senate. What message does it send the public to accept senators sponsoring legislation benefiting close associates without disclosing those relationships? The message we should send the public is to stand firm, say we do have standards, we can demonstrate ethical behavior, and we will treat all members of the public fairly without giving advantage to those with whom we have a close personal or professional relationship. Thank you very much for the time you've taken today in reviewing this matter. We believe we have demonstrated that Senator Champion's sponsorship of multiple pieces of legislation benefiting a legal client constitutes a violation of Senate rules and our code of ethics and is deserving a response from the Senate Subcommittee on Ethical Conduct. Thank you.
Thank you, Senator Kroon. Are there questions for Senator Kroon? Seeing no questions from members of the subcommittee, now I'll ask Senator Champion and Mr. Zoll to come forward to make the presentation of Senator Champion's defense. Oh, yeah, you do. You have questions. Fantastic. Mr. Zoll.
Senator Kroon, did I understand correctly that your position is that a conflict arises from Senator Champion's obligations to his legal client, correct?
Senator Kroon.
Madam Chair, can you remind me your name again? I'm sorry.
David Zoll.
Mr.
On behalf
Zoll.
of Senator Champion.
Sorry. Thank you, Madam Chair. Mr. Zoll. I think it stems from both his duties, professional duties under our Senate rules, combined with his ethical duties under the lawyer rules.
Mr. Zoll.
With respect to his obligations as a lawyer, am I understanding your position to be that he was prevented from disclosing information regarding the fact that Salem Inc. was a defendant in the real estate foreclosure matters?
Senator Kroon.
Madam Chair, Mr. Zoll, I wouldn't say it'd be an outright prohibition, but there certainly would have needed to be steps taken in order to disclose the existence of the lawsuits and the information surrounding the lawsuits to complete a picture to the members of the Jobs Committee and the Senate as a whole.
Mr. Zoll.
The Minnesota Rules of Professional Conduct that relate to lawyers don't prohibit an attorney from disclosing public information about their clients, do they?
Senator Kroon.
Madam Chair, Mr. Zoll, if the matter, I believe, actually get the rule in front of me, there's specific language, if it is a matter of generally understood or in the public, then that specific rule, I think there's an exception in that specific rule.
Mr. Zoll.
And the lawsuits you referenced were publicly filed. The complaints were publicly available through the court's website, as well as the stipulations for dismissal following settlement, correct? That was all information that was publicly available and was publicly available.
Senator Kroon.
Madam Chair, thank you, Madam Chair. Mr. Zoll, some of it was public. I believe the first two dismissals would have been, but not the third.
More questions, Mr. Zoll?
Can you point to any examples where the type of disclosure you are claiming is required here was made by a member of the Senate?
Senator Kroon.
Madam Chair, Mr. Zoll, I'm not aware of any bill that's been presented by a lawyer that would direct public funds to their clients. So I'm not familiar with a case like this since I've been here, which this is my first term, so it would be January of 2023.
Mr. Zoll.
Final question. Do you agree that Senator Champion did not have a personal financial interest in either of the bills that he introduced?
Senator Kroon.
Madam Chair, Mr. Zoll, I don't know. I have no evidence to suggest that he was paid for his legal services or had a financial interest, as I've stated in my opening statement. However, the complaint that I've set forth under 56.1 and 56.3 and the Code of Ethics, it does not require that Senator Champion was paid for his legal services or that he had a financial interest in that legislation.
Mr. Zoll.
Is there anything in Minnesota Statute 10A07 that would require the disclosure of an appearance of a potential financial interest or conflict?
Senator Kroon.
Madam Chair, Mr. Zoll, my complaint is not premised on Minnesota Statutes 10A.07. My complaint is premised on Minnesota Senate Rule 56.1 and 56.3 in the Minnesota Code of Ethics. And it's my position that there absolutely is a duty under those rules in the Code of Ethics to disclose that relationship.
So to
Mr. Zoll.
make sure we're on the same page, you're not relying on disclosure pursuant to 10A07 at all in connection with your complaint?
Senator Kroon.
Madam Chair, Mr. Zoll, I believe that was at issue in the advisory opinion. That is not at issue in my complaint. It's not cited in my complaint. My complaint is independent of the financial conflict of interest statute 10A.07.
I know I said final question once before.
That's all right. Continue, Mr. Zoll.
This might actually be the final question.
That's fine.
So to make sure that we're focused on the right scope of the complaint, is it fair to say that you're really focused on the language in 56.3 defining improper conduct, that it violates an accepted norm of Senate behavior, betrays the public trust, or that brings the Senate into dishonor or disrepute? Is that really the focus of your complaint?
Senator Kroon.
Thank you, Madam Chair, Mr. Zoll. That is the focus of Rule 56.3. There's also the Code of Ethics provision as well. And I can get you that site. It was in my opening statement. That is section 1.30 of the Code of Ethics. That is what my complaint is based on, and that is what my comments were directed to. And with respect to that, it makes no difference whether or not Senator Champion was paid for his legal services. He had there certainly was an appearance of a conflict. He had information that he obtained as a lawyer for Salem Inc., representing them in litigation that could have adversely affected his client, and he made the decision to not disclose that to his colleagues in the Jobs Committee and to the senators as a whole when he presented the bill on the floor. To me, that is a violation of our Senate rules and our Code of Ethics.
And would you agree that that is
Mr. Zoll.
would you agree that that is a subjective standard?
Senator Kroon.
Thank you, Madam Chair, Mr. Zoll. Well, we have committees like this one to adjudicate whether or not our rules have been violated. So obviously there is a committee that makes that decision. So would be a certain level of subjectivity in every single ethics complaint. But to me, as the person that brought this complaint, this one is pretty clear cut. If you are sitting next to your client at a committee table in the Senate presenting a bill that will appropriate $3 million of public funds, you better disclose that to your colleagues. And it's inexcusable for Senator Champion to have not disclosed that fact. And more importantly, I believe it violated Senate rules and our Code of Ethics.
Okay.
Mr.
Zoll.
Sorry. Do you agree that that is a subjective standard as opposed to an objective standard?
Senator Kroon.
Thank you, Madam Chair. As I said, there's always going to be a certain level of subjectivity whenever you have an ethics complaint, which is why we have an ethics committee that adjudicates them. Could there be gray areas in the rules? Of course. But in my view, in this particular case, to me, the evidence is clear. And to my co-authors of this, the evidence is clear that in this particular case, the rules were violated and the code of ethics were violated by Senator Champion.
All right, let's move on then for the presentation from Senator Champion and Mr. Zoll. Go ahead and proceed, Mr. Zoll.
Thank you, Chair Pappas and members of the subcommittee. We are not here today because Senator Champion failed to uphold the highest standards of ethical conduct or because he violated any norms of Senate behavior or betrayed the public trust. We are here because Senator Champion is a tireless advocate for his North Minneapolis community. He dedicates himself to the community as a lifelong resident of North Minneapolis. He dedicates himself to the community in his public service as a member of the Minnesota Senate, and he dedicates himself to the community in his professional life by providing pro bono legal services to support the individuals and organizations working to build a stronger community. Senator Champion has earned the trust of his community through his hard work, and I hope that he has earned the trust of his fellow senators through his 13 years of service in this body, and that this subcommittee will find that there is no probable cause to believe that an ethical violation occurred. To be clear, Senator Champion did nothing wrong. The subcommittee already concluded that Senator Champion's past pro bono representation of Reverend McAfee in Salem, Inc. did not create a conflict of interest with respect to the legislation introduced in 2025 to provide funding for an initiative to reduce crime in his community. And although the subcommittee chose not to reach the question of whether a conflict existed with respect to similar legislation passed in 2023, the facts are indistinguishable between those two circumstances. There was no financial interest for Senator Champion, and therefore no conflict of interest under the Senate rules. As you know, from the hearing on his request for an advisory opinion, Senator McAfee provided pro bono representation for Salem, Inc. and Reverend McAfee in a series of real estate foreclosure actions in 2022. The litigation arose from the financing for several properties owned by Salem, Inc., which were part of a program to address a housing crisis in North Minneapolis. The litigation was settled through mediation, and a full settlement agreement and mutual release was signed on October 7th. The agreement included stipulations of dismissal to be filed by the plaintiff, not by Salem, Inc. or by Reverend McAfee. The signing of the mutual settlement agreement and release was the end of Senator Champion's representation of Salem and Reverend McAfee. The plaintiff filed those stipulations for dismissal in the court on February 6, 2023. And at that point, the timing for the formal orders of dismissal was in the hands of the court. The parties had no power to control when the court ultimately entered the orders of dismissal. More than a month later, on March 20th, 2022, Senator Champion introduced Senate File 2970, which allocated funds to the Community Action Partnership of Hennepin County. And the legislation directed CAP of Hennepin County to provide a portion of those funds to 21 Days of Peace, a violence disruption and workforce development program run by Salem, Inc. And here I think it's important for the subcommittee and for members of the public to hear that this wasn't a direct appropriation to Senator Champion's former legal clients. It wasn't a blank check for $3 million that was signed over. It was an appropriation to Community Action Partnership of Hennepin County, which entered into a funding agreement with DEED, and to receive the money that was addressed in that legislation, 21 Days of Peace, had to submit proof of the expenses that were consistent with the purpose of the legislation, and it was done on a reimbursement basis. That needs to be remembered, the full context of what was being approved here. And again, this was all addressed in the proceedings relating to Senator Champion's request for an advisory opinion. In the finding that he did not have a conflict of interest when he introduced similar legislation earlier this session should have put an end to this matter, but it did not. Instead, complainants, relying on incomplete and inaccurate recitation of facts set forth in newspaper articles, allege not that Senator Champion had a conflict of interest that must be disclosed under Rule 56.4, that's already been addressed, but rather allege that by not disclosing his past pro bono representation of Salem Inc. and Reverend McAfee in an unrelated matter, Senator Champion somehow violated a rule or administrative policy of the Senate, violated norms of Senate behavior, betrayed the public trust, or somehow brought the Senate into disrepute or dishonor. The complaint fails for several reasons, but first I want to briefly address the articles upon which it relies. Both articles referenced in the complaint wrongly assume that Salem Inc. and Reverend McAfee were current clients when the legislation was introduced. This is not correct, and I won't go through all the details again, I just did. But the fact of the matter is, these claims, these cases were settled in October of 2022, and stipulations for dismissal, the final act taken by the lawyers to end a legal proceeding, were filed in February of 2023. The only tail remaining on any of those cases was for the judge to sign the orders of dismissal. Second, the ethics experts that are quoted in each of these articles offered opinions that were based on an incomplete understanding of the facts and their views of what Minnesota's conflict of interest laws should be. Not what they are, but what these experts thought that they should be. These articles are not a reliable basis for bringing an ethics complaint. Senator Champion's past representation on a pro bono basis for which he did not receive any compensation cannot give rise to a violation of any ethical standard in the Minnesota Constitution or in the Senate rules. Similarly, complainants do not point to a single example of a similar relationship being disclosed, either in their testimony today or in their complaint, in the course of introducing or debating a piece of legislation, as they must do in order to demonstrate that such disclosure reflects accepted norms of Senate behavior. That is to say, if the disclosure that they claim needed to be made is an accepted norm, there would be numerous examples of such disclosures being made in the past. They point to none. Accordingly, all that remains in the complaint is the subjective notion that by not disclosing his past representation of Salem Inc. and Reverend McAfee, even though it didn't create a conflict of interest due to any personal financial interest, somehow betrayed the public trust or brought the Senate into dishonor and disrepute. For this, the complainants point to his obligations to a former pro bono client, that somehow that may have prevented him from being fully forthright with his colleagues in the Senate when introducing this legislation. To be clear, the complainants base their argument on a hypothetical possibility that Senator Champion might have had information regarding his former clients that he could not disclose. This doesn't survive even the slightest scrutiny. First, the one thing that complainants point to in their testimony today is it might have been useful for the committee to know that there were these foreclosure actions, which had been settled by that point in time. There's nothing in the ethical rules that limits or prohibits a attorney from disclosing public information. And this was all public information. Also, it's important to remember, this is completely unrelated. The foreclosure actions focused on the project to provide housing opportunities in the community relate in no way to 21 Days of Peace, a project focused on disrupting violence and creating workforce opportunities for which Salem Inc. received compensation only on a reimbursement basis. There's no connection at all between these two items. Rule 1.9, which exists to prevent a lawyer from disclosing information that might disadvantage his former client, simply doesn't apply here. The rule exists to prevent an attorney who's entrusted with information, confidential information relating to their client, from using it in subsequent representation of another client to the disadvantage of the former client. All right, there are a lot of references to clients and disadvantage in former and present, but let me break down what this is really intended to address. It's intended to address, for example, an attorney who gained information about a client's business operations while negotiating a contract, and to say that that attorney can't turn around and use that information that relates to his former client's business operations to help a competitor down the road, maybe when they're suing that client or former client over some issue. That simply does not apply here in these completely disparate circumstances relating to the foreclosure actions and the proposed legislation to provide funding to disrupt violence in North Minneapolis. The mere fact of his prior representation may hypothetically have limited his ability to debate the bills fully and candidly. And to be clear, it did not affect his ability to debate the bills fully and candidly, does not create an obligation to disclose the past pro bono representation. If the test for disclosure of a prior relationship, if the test for disclosure where the prior relationship may affect the full and candid debate of bills is what complainants assert here, members of the Senate would be required to disclose a myriad of current and former relationships anytime they debate a bill that may benefit a nonprofit they support, where they volunteer their time, or a former business partner, or their child's Little League baseball coach. Senator Pappas, in your opening comments, you referred to a slippery slope. This is the first and dangerous step down a slippery slope because there's any number of relationships that senators have because of their role in the community that could create a new subjective disclosure standard that it would be virtually impossible to enforce on a reliable basis. Members, there is no conflict of interest here. In using a vague and malleable standard to punish Senator Champion for his active involvement in advocating for his community, both at the legislature and in his professional life, would set a dangerous and disappointing precedent for the Minnesota Senate. For all these reasons, Senator Champion respectfully requests that the subcommittee find that there is no probable cause to find an ethical violation and dismiss this complaint. Thank you.
Thank you, Mr. Zoll. Are there any questions from Mr. Zoll or Senator Champion from members? Senator Kroon, any questions? Whatever. You can go first. Senator Matthews.
Thank you, Madam Chair. Thank you, Senator Champion and Mr. Zoll. I do have a list of questions that I want to walk through based on your presentation. First of all, I want to highlight and clarify, Mr. Zoll, is it your understanding, really quickly, tying back to the advisory opinion, is it your belief that the subcommittee merely found no conflict of interest, as you stated, or specifically found no financial conflict of interest under 10A.07?
Mr. Zoll.
Chair Pappas, Senator Matthews, it is my understanding that the subcommittee addressed what was in the request for the advisory opinion, which was a determination as to whether there was a conflict of interest under Rule 56.4 in Minnesota Statute 10A.07.
Senator Matthews.
Madam Chair, thank you. And Mr. Zoll, likely true, but the more direct language is the subcommittee in its deliberations specifically used the language of finding no financial conflict of interest under 10A.07. And I do believe that is an important and clear distinction that needs to be made. Mr. Zoll, under Minnesota rules for lawyers, what obligations continue for an attorney-client relationship after the conclusion of a case?
Mr. Zoll.
Chair Pappas, Senator Matthews, the primary obligation that is pertinent to this matter is the obligation under Rule 1.9, which prohibits lawyers from using information obtained in the course of the representation of a former client to that client's disadvantage in the subsequent matter.
Senator Matthews.
Thank you, Madam Chair. Mr. Zoll and Senator Champion, I want to direct you to Exhibit C that's in the complaint. I don't know if you have it in front of you, but it's the language of the, I believe it would have been the omnibus bill from 2023. And I'm happy to give you a moment while we're getting that pulled up.
Give me 1 second.
Page, we have a page number, page 15,
I'm looking, yeah.
Exhibit C.
Exhibit C?
Yeah.
Yes.
Okay, here it is. And what page number, Madam Chair?
Page 15
Page 15.
of the complaint.
So we do have Exhibit C, if that's what you're referring to.
Yeah, Senator Matthews, and
Thank you, Madam Chair. Yeah, if you have a paper copy, it probably has the original page document that this is pulled out of. But I'm being told by Senator Pappas and the staff here that if you're looking at the PDF online, it would be page 15 of the overall complaint. But Exhibit C has page 238 as the marking from the omnibus bill from 2023. And my question is, comment was made that this was not a direct appropriation to 21 days of peace, but I'm wanting to highlight, wouldn't you agree that it's both are named in the bill, that the bill that was passed by the legislature in 2023 is directing $3 million for a grant to Community Action Partnership of Hennepin County. And the very next paragraph directs and says 1.5 million is for grants to 21 days of peace, and that is also spelled out in the legislation that was passed into law.
Senator
Madam Chair,
Champion.
Senator Matthews, thank you so much for the question surrounding Exhibit C. As you see that on line, starting at line 238.6, it says for a grant to Community Action Partnership of Hennepin County. The reason why that's important, and then later it breaks down where the two organizations that the Community Action Partnership would work with in order to make sure that they fulfill the intent of this appropriation. The reason why that's important is because it is Hennepin County, as you know, Hennepin County group that would enter into a contract with DEED. And with DEED, they will articulate with clarity what the measurements are, what needs to be done, and then Hennepin County, Community Action Partnership of Hennepin County would then engage with not only 21 Days of Peace, but also A Mother's Love in order to say, here are the expectations, here are the things that you have to do in order to become a recipient of any of this money. Now, you know that then 21 Days of Peace and Mother's Love must then go out and do the work that is required and then submit an invoice. That invoice is submitted to Community Action Partnership, who then submit the information. Well, they look at it, make sure that it's right and that the work that they said that they did, that in fact they did it, and then Community Action Partnership submits that invoice to DEED. And then DEED looks at it. And then if DEED looks at it and says yes, then the invoice is paid because that's reimbursable. If deed says no, there's then no money that gets extended from deed to community action partnership, and therefore there would be no money to a mother's love or 21 days apiece. So that's the process in order to make sure that there's always layers of accountability and transparency and support.
Madam Chair.
Senator Matthews.
Thank you, Madam Chair. And I appreciate those layers that are involved with it. Point I'm highlighting is that there is a specific earmark of at least $1.5 million mentioned here that's specifically named out in this bill. Senator Champion or Mr. Zoll, based on a question that Mr. Zoll asked to Senator Kroon and based on a statement that you made in your own presentation about not citing any other senator who's made such a disclosure of any bills previously, can you give to the subcommittee an example of a senator who even authored a bill to fund a current or former legal client?
Mr. Zoll.
Chair Pappas, Senator Matthews, I don't have an example of that, but I do note that the burden here of demonstrating what is an accepted norm of Senate behavior is on the complainants. And to the extent that they claim that this type of disclosure is required, they ought to be able to demonstrate that this is a disclosure which typically happens. That is what would be reflected by an accepted norm of Senate behavior. I also think it is too narrow to look at whether it is a lawyer legislator advancing a bill related to in any way, shape, or form a client versus taking a more expansive view of the conflicts that would be, or the potential conflicts or appearances that would be encompassed within the broad sweep of the underlying premise underlying the complaint and the slippery slope that Chair Pappas warned about.
And Madam Chair, if
Senator
I can
Champion.
also say this, in addition to what my counsel just said, one of the reasons why you cannot point to definitively others who have done it is because the Senate has always adhered to a conflict and disclosure being required under Minnesota Statute Section 10A.07 to say if you have a financial interest, then you are required to make this disclosure. That is what's outlined in our rules. That's what is also referred to even in our Senate rules, right? Even when you look at our temporary rules of the Senate state of Minnesota, if you go there, you will see specifically it redirects you to, if there's a conflict of interest, it goes to 10A.07. It doesn't go to anything else. So in the Senate, we've been abiding by what that rule prescribes and what we are to look at when it comes to disclosure. So it's sort of one of those questions, Senator Matthew, that I can understand you asking, but it seems to undermine what we've put in rules. And if there's something that we believe that should happen, if there's an added layer of disclosure that we would want, then we should put that in rule, and we should put that in law. But the unfortunate thing is what happens and what we do when we look at broad-based speculative notions when we think in terms of our rules is that we can allow a reporter or others who may be well-intentioned to now start drawing these correlations when there are none. We allow individuals who are quote-unquote experts say, well, we think Minnesota has the weakest conflict of interest rules in the country. That may be their opinion, and if we believe those rules should be changed, then we have the responsibility then to step up with a bill and propose changes to their rule. But it's unfair to now make a senator responsible for what others believe or perceive should be the changes in the rules, and then say, but we're going to point at you, and we're going to use our broad-based, notion of saying, if you created the appearance, we should not do that. And that's unfair to anyone who would sit in this seat and now be subjected to whether something was in Article 1 or Article 2 or Article 3, and now we're shadow boxing. And so with that being said, we have an interest and a conflict as outlined in the law. And I, for one, was abiding by exactly what our conflict of interest rules provided. So that's probably why we can't point to other things. And here's the other thing that I'd like to say lastly. We also have to be very careful by us just looking at attorneys and not looking at others who may be on boards. What if you decided to help a nonprofit and do some accounting work? What if you decide to be that coach? What if you decide to be, you fill in the blank? Where is the line for us to say, here's when you should disclose something? And then what about another question? How long must I be removed from representing a client before I can bring a bill for that person because they're a member of our community? And I know a lot is said about whether I knew someone or not. I'm proud of knowing people in my community. It is my job to know people in my community. I was born and raised in this community. So to suggest that I won't know someone and now to suggest that that is a problem, I would hope that we wouldn't think that particular way. So thank you, Madam Chair.
Senator Matthews.
Madam Chair and Senator Champion, Mr. Zoll, I don't think there's anyone on the subcommittee that is making the argument that anytime you know anybody or shook anyone's hand, you have to come disclose it. I think we're highlighting and we're questioning whether certain special relationships, of which attorney-client privilege is one of them, is one that should be disclosed for potential conflicts of interest. And you want to keep, both of you are trying to keep taking it back to 56.4 and 10A.07 and seem to be making the case that any potential conflict of interest is financial in nature, that there's nothing outside of financial conflict of interest. But I think the universe is broader than just financial conflicts of interest, which is why we're focusing on 56.1 and 56.3. I think that the reason why we don't have an example of a senator who's authored bills to fund former legal clients is that I don't recall it ever happening. And I know that thousands of bills get introduced each year, and perhaps there are others that just are introduced and are dropped, but I would give the same advice to someone that was on my side as to the other side of, you probably shouldn't do that or should disclose that or something of that nature. So we're trying to argue, well, there's no one else that has disclosed anything, but I think that flips on the other side that there's really no other example that I know of that is like this, proposing to give funds to former legal clients. So let me ask you, based on the language in 56.1 and 56.3, why is conduct like this that would give appropriations to organizations with which there was a previous attorney-client relationship, why would that type of conduct meet the accepted norms of Senate behavior?
Mr. Zoll.
Chair Pappas and Senator Matthews, it meets the accepted norms of Senate behavior because it is consistent with the one objective standard that this body has provided to its members for determining whether disclosure is required. You say that maybe there should be a rule that applies specially to relationships like an attorney-client relationship, or maybe it's a doctor and patient relationship, whatever it might be. Maybe that is something that this body ought to take up, but that's not a rule, and it's not a standard, and it's not a norm which presently exists. You're engaging in a line drawing process or a question about determining where the line ought to be drawn. It's already been drawn. And the Senate rules should not be used as a trap to be sprung on a senator who complied with the express disclosure requirements set forth in the Senate ethics rules in Rule 56.4. And there may be circumstances that could come up that would bring dishonor or disrepute in the Senate, as is described in Rule 56.3. But this is not that circumstance, a circumstance in which a senator has fully complied with the disclosure requirements, the express disclosure requirements in 56.4 and 10A07 can't possibly be a scenario where you can determine that he still somehow has violated the norms of the Senate when he has complied with the one express rule provided and guidance provided on when disclosure of these relationships is required.
And
Senator Champion.
Just briefly, and I think it's important for us to not just say what 10A.07 by just citing the statute, but I think it's important for us to read and know what it says in 56.4. So for those who are listening, I'm going to read it. Members of the Senate must disclose potential conflicts of interest in the discharge of senatorial duties as provided in Minnesota statute section 10A.07. That statute says you must disclose when you, as the senator, has a personal financial interest. That's what we have laid out. And should the Senate wants to change its rules or expand them, we certainly invite that. But that should not be this speculative standard for a person like me who adhered to the Senate rules. I had no financial interest. Everyone knows that I did it pro bono, and we just want to just make sure that we also focus on what brings honor to us as well. I think my volunteerism brings honor to the Senate. I think to work in your community and for people to see that it's important to invest in your community, that brings honor.
Madam Chair.
Senator Matthews.
Thank you, Madam Chair. I think this will be my last one at this point. And again, I believe the parties here are trying to bring us back to 56.4 and the financial conflict of interest when it's broader. I disagree with the notion that there's nothing in our Senate rules about it. I believe the Senate rule is 56.1 and 56.3. which lays that out for any conduct that can be far outside the realm of just a financial conflict of interest. So, Senator Champion and Mr. Zoll, how would this conduct of authoring legislation that would direct funds to former legal clients not betray the public trust and bring the Senate into dishonor or disrepute?
Mr. Zoll.
Chair Pappas and Senator Matthews, I would offer what I said previously, that it is an unfair trap to spring upon a senator to conclude that they somehow are bringing dishonor upon the Senate when they have complied with the one objective standard that is provided for determining whether disclosure of a relationship like this is required. And I again caution the members of the subcommittee about the slippery slope that they may step upon with the deliberation and consideration of this complaint. When is it far enough removed from prior representation for a lawyer legislator to be able to offer a bill? Is it a conflict for Senator Kroon to have authored bills relating to the mortgage foreclosure and redemption process when in his legal career he represented entities that were involved in the mortgage foreclosure process? When is that line, when is it safe? And it is fundamentally unfair to put a legislator in a position of needing to, of fully complying with the one objective test that is provided and saying that they still haven't done enough. That is fundamentally unfair.
That's all for now. Thank you, Madam Chair.
Thank you.
Senator Miller.
Thank you, Madam Chair. Just in an effort to bring the committee back to what the actual complaint is about, just so we're not wasting anyone's time, there's been a lot of discussion about Senate Rule 56.4. But if you read the ethics complaint in front of us, it says, quote, Senator Bobby Joe Champion violated Senate Rules 56.1 and 56.3 by sponsoring legislation appropriating money to a legal client without disclosing the client relationship. Senator Champion authored legislation in 2023 and 2025 directing money to this client, including legislation that was signed into law in 2023 and sent $3 million to the client. So just as we continue discussions today, there's been a lot of discussion about Senate Rule 56.4, but Senate Rule 56.4 and Minnesota Statute Section 10A.07 is not even mentioned in the complaint in front of us. So I hope we can just kind of focus our discussions today on the ethics complaint in front of us, which are Senate Rules 56.1 and 56.3.
And Madam Chair?
Senator Champion.
And thank you, Senator Miller, for that perspective. The only reason why I want to make sure that we're really clear is because in the complainants, in the complaint, they mention past behavior using that as a foundation as to why they believe that I violated some rule. And then allowing themselves to view the past behavior through the lens of articles. Those articles all focus on 2023. And Madam Chair and Senator Miller, that's why we're back there and constantly wanting to make sure that this committee is clear that I have not violated any rules of conflict based on our rules. And if we're going to go down a slippery slope of saying we're going to make this determination as it pertains to 56.1 and 56.3 as a result of articles, a reporter can say that any of us have done something, and whether they're right or wrong, we will find ourselves sitting in this seat because we don't have the power of the pen. But as members, we have to also be conscious of the decisions that we're making when it comes to filing these ethical complaints and bringing a member here and using an article or a reporter's interpretation of that and how that writing can impact the thoughts or ideas of any member of the community. And I just think that we have to be very cautious, and thank you so very much, Senator Miller, but I will agree, even if you look at, if there's no conflict and we're saying under our Senate rules there's no financial conflict that didn't require disclosure, fine. If there's a desire for someone to say, but if there are these circumstances that we think additional disclosures should be made, then we should say that, and we should put that in our rules. But don't allow, in the middle of a game or in the middle of a event, for us now to change the rules because there's been no other guidance that has said that, and then we will use it to the detriment and the chagrin of the legislator like me who's sitting in this seat.
Did any other, Senator Kroon, did you have questions for Senator Champion or Mr. Soul? Senator Kroon.
Thank you, Madam Chair. Senator Champion, I want to make sure I understood you correctly. Is it your position that under current rules, you are never required to disclose a relationship unless there is a financial stake under 10A.07?
Senator Champion.
And Madam Kroon, that is the objective standard that is given in our Senate rules, and that is what I adhere to. Because any volunteerism, if that's what I'm going to do, or if you're going to volunteer, that you should be encouraged to volunteer. And in fact, Senator Kroon, you are a lawyer as well as I am. Our profession encouraged us to do pro bono work. We have to now report it. And so I just want us to be very clear that the work that I did for Salem Inc. and Reverend Jerry McAfee ended on October 7, 2022. everything ended on that particular day.
Senator Kroon.
Thank you, Madam Chair. Thank you, Senator Champion. What if, other members have disclosed situations where family members might be getting something? What if it were a parent or a child, but you still had no financial stake? Would you not disclose that if you were presenting a bill that would benefit a child or a parent or another close family member?
Madam Chair.
Senator Champion.
I'm certain that the last name would give it away every single time because my children's last name is Champion. And so if they sat at the dais or the testifiers table, and if there was that name, we certainly would talk about it. Let me just be clear, because I don't want this to be misconstrued. We have the responsibility of making sure there's no financial interest because we do not want there to be a conflict, and we do not want individuals going out doing things using the power of the state's purse in order to give someone a benefit that we are indirectly or directly going to receive a benefit from. The history of the legislature is clear that we're a part-time legislature, that we know there are going to be times when we're going to be out working and doing a multitude or multiple things, right? And so I want to make sure that if there was something that I should disclose to really make sure that I'm not violating any rules, I certainly do that. And there's nothing in our conflict of interest rules that requires disclosure other than when when there's a personal financial interest or if I have a business that is going to benefit. That's according to our rules.
Senator Kroon.
Thank you, Madam Chair, and Senator Champion. I'm trying to understand the answer to the question because you said if they had the same last name as you, then you would have a discussion about it. What if they didn't have the same last name? And what if the members of the committee didn't know that person was related to you and you had no financial stake in it? Do you believe you would have an ethical obligation to disclose that family relationship in that situation?
Senator
Chair,
Champion.
Under our ethical rules, I am to disclose it if there's a financial interest. Do I think there should be a potential change when we think in terms of our rules? Certainly. But again, how far down should I go? Should it be my sister? Should it be my mother? Should it be my distant cousin? I'm just trying to make sure that we're doing everything in order to be ethical and responsible.
Mr. Zoll.
I would also like to briefly respond to this. And just as Senator Miller brought us back to the actual complaint in front of the subcommittee, I want to bring us back to the actual facts in front of the subcommittee, which relates to Senator Champion's former client that he represented on a pro bono basis. And in that sense, his relationship is fundamentally no different than an individual who would volunteer on a board of directors for a nonprofit organization. And it maybe even less so of an interest there. And to the extent that the complaint relies on Rule 1.9 and its ability, a lawyer's ability to speak directly and forthrightly regarding legislation, there really is no difference between that and what would be experienced by someone who volunteers with a nonprofit organization or maybe as a business partner, or a former business partner or a neighbor, whoever it might be. There's myriad relationships that could influence how someone views the merits of a bill just based on their own past experience of knowing what an organization does or being familiar with it. And that's where the line drawing post hoc, when someone has complied with the disclosure requirements, becomes a dangerous precedent for this committee to pursue.
Senator Kroon.
Thank you, Madam Chair. Senator Champion, there's been a lot of talk here about Salem Inc. being your former client, but isn't it true that you were the attorney of record in at least one of the litigation files at the time you introduced the bill and at the time you presented the bill to the Jobs Committee in 2023?
Senator Champion.
Thank you, Madam Chair, and thank you, Senator Kroon, for the question. Senator Kroon, the answer is no. Here's why. on October 7th of 2022, there was a signing of a mutual settlement agreement and release. Paragraph 2 of that mutual settlement and release was the release of all litigation and complaints. As a part of the exhibits for that mutual settlement and agreement that I did provide already to this committee, it also included the agreed upon dismissals without prejudice that were supposed to be filed. And on those dates, it was December 6th. Now, we recognize that we could also look at the exhibit for October 5th, where there was also this is 2 days before the October 7th, October 5th of 2022, and dismissals where it says the attorney for the plaintiff is responsible for filing the dismissals. So on October 7th, when all those things were finalized and done, the last act, what didn't have anything to do with me, was for the plaintiff's attorneys just to file those dismissals. So unfortunately, I was no longer involved, and then we also supplied a letter that from the client that says after October 7th, I had nothing else to do with the case itself. But we recognized that there was a filing that was after I had filed the bill that did not come from me, but it was a dismissal of the lawsuits.
Senator Kroon.
Thank you, Madam Chair and Senator Champion. My question was not about whether you were no longer involved in representing your client as you saw it, or that there was nothing else left for you to do. My specific question for you is, isn't it true that you, and we can look at the, you can look at the exhibit if you want, which is Exhibit J to the complaint, and I'm specifically talking about court file 27-CV-22-9031, which, if you look at it, wasn't dismissed until April of 2023. So, if you, and your answer to my question was no, that you said you were not the attorney of record when you introduced the bill and when you presented it to the Jobs Committee, then if you weren't, who was the attorney of record?
So two things.
Senator Champion.
Thank you, Madam Chair. And just for clarity, my work had been done October 7th, 2022. There were some ministerial or administrative things that were supposed to happen after that. And the plaintiff's attorney did, as required, file those dismissals. So to the extent that he filed those after I had finished the case and introduced the bill, then we would certainly say that there was that filing afterwards. And I can't control when that filing happened or even when the court provides a final judgment, for lack of a better word.
Senator Kroon.
Thank you, Madam Chair.
Oh, thank you, because I feel like this question has been answered multiple times. Did you have any additional questions?
Thank you,
Or are you
Madam
ready
Chair.
for your final comments? You get 5 minutes for closing remarks.
I understand. I do have questions left.
Okay.
And when you tell me I no longer can ask questions, then I'll stop asking questions. But
Well, Senator Kroon, I'd just like you to maybe ask a different question.
well, thank you, Madam Chair. I appreciate that. But what I'm struggling with on this particular issue is there seems to be a statement that Salem Inc. was Senator Champion's former client, and what I'm trying to show is that that is untrue. It was his current client. He was the attorney of record in a litigation file at the time he introduced the bill and at the time he presented it to the Jobs Committee, and that is the point that I'm trying to understand, how Senator Champion can say he was not the attorney of record when he was the attorney of record until that lawsuit was dismissed by the court in April. And so I'm not sure if he doesn't understand what attorney of record means, but if you are the attorney of record and there's no withdrawal of counsel, no substitution of counsel, you are that client's lawyer until the case is dismissed, period. This isn't a gray area. And so what I'm trying to get at is that Senator Champion, Salem Inc. was the current client, not a former client when he presented this bill. So that was the point I'm trying to get at. And I have other questions as well, but you can let me know if I'm allowed to ask.
Continue with your questions.
Madam Chair, may I briefly respond to this?
Mr. Zoll.
I want to make a few points here that I think will be helpful for the subcommittee. First, by February 6th, when the plaintiff filed the stipulations of dismissal that were required to dismiss the lawsuit, by that point in time, Senator Champion had completed everything he needed to do to wrap up his involvement representing Salem Inc. and Reverend McAfee. It's beyond his control when the court gets around to signing the proposed orders that were submitted. What might be helpful here, too, to understand is what would have been the recourse for Reverend McAfee or Salem Inc. if the plaintiff never got around to filing those stipulations of dismissal? It wouldn't have been any proceeding in that ongoing litigation. That would not have been where that would have occurred. It would have been a separate action brought by Salem Inc. or Reverend McAfee, by whoever it was that was representing them, for a breach of contract claim because of the plaintiff's failure to comply with the obligations in the settlement agreement to see through the dismissal of the litigation. It is a simple and true fact that Senator Champion's representation and his work required to see through that settlement had been completed in October, and beyond doubt, by February of 2023, the documentation had been filed with the court that was necessary to bring his involvement in the case to a close. All that remained was for a Hennepin County judge, several Hennepin County judges, because they were assigned to different matters, to put pen to paper and sign those orders.
I just feel compelled to mention that Senate Rule 56.3 states improper conduct includes conduct that violates a rule or administrative policy of the Senate, that violates accepted norms of Senate behavior, that betrays the public trust, or tends to bring the Senate into dishonor, disrepute. Just to remind the parties that, I think we've had enough discussion of this particular point and that we need to move on. Thank you. Senator Miller.
Thank you, Madam Chair. And to that point, and a question for Mr. Zoll, because he brought it up earlier about members being involved in their community and serving on boards of directors. And I, for one, think Senator Champion should be applauded for his work in the community and his work that he does.
I'm sorry, that was not an invitation to applaud. That was a form of speech.
And I commend him for the pro bono work that he does, but that's not the question that's in front of us right now. But Mr. Zoll, like Senator Champion, I'm very involved in the community where I was born and raised, and I just have a question for you. I want your opinion on something. If I serve on the board of directors for a nonprofit organization in the community that I live, completely volunteer, but I am advocating for appropriation for this organization for X amount of dollars, and I do not disclose that I am a member of the board of directors or that I am involved directly with this organization, volunteer, so be it, but I'm involved with this organization. Do you believe that that betrays the public trust or that tends to bring the Senate into dishonor or disrepute if I do not disclose that information?
Chair Pappas.
Mr. Zoll, do you want to respond to that?
I will, because I believe it was the question was posed to me. I do not believe that the conduct you described would betray the public trust or bring the Senate into dishonor or disrepute. And for this simple reason, and I understand that maybe we're going back to Rule 56.4, but this body has established an objective test for you and any other member who's involved in an organization to determine whether disclosure is required. And in the circumstance you described, you have nothing to gain personally from the legislation you proposed. An organization for which you volunteer may benefit from it, but all that tells me, and I think all that would tell your colleagues, is that you are proposing legislation that you believe benefits your community. That's the reason I assume that you volunteer for this organization. That's the reason that you would propose legislation that supports its effort. I assume that that is the reason that senators advance every bill that they introduce in the Senate, is because they believe that it is in the best interest of their community in the state of Minnesota. And doing that in no way brings dishonor or disrepute upon the Senate.
Madam Chair.
Senator Miller.
Here's the challenge that I have, and it was mentioned that this is all because of an article that was written in the media, and that might be the case, but the reality is what the media was writing about was a bill that was introduced. And not only a bill that was introduced, but a bill that was introduced and passed and signed into law. And the challenge I have, Madam Chair and members, is the part that says that betrays the public trust. And the reason I bring this up is just this past weekend I was home and I was at an event that had nothing to do with the work that we do here. It was a Polish Constitution Day dinner at the Polish Heritage Museum in Winona. I don't volunteer for the organization. They asked me to come speak. I spoke. They offered to pay a stipend. I did not accept a stipend. I was there speaking as a member of the community. And I had multiple people come up to me at that dinner to talk about this very situation that we're talking about today, including someone who brought a newspaper where I was quoted from when we met last time. And she said, Jeremy, I think you're right on this. And the reason I bring that up is that part in Rule 56.3 that says betrays the public trust. Now, Mr. Zoll, I disagree with you. I think that if I am a member of the board of directors for a nonprofit organization and I introduce a bill that would directly benefit that organization, in my opening comments presenting that bill, I would share proudly that I am on the board of directors for this particular organization. Now, I haven't done that any time that I recall in the Senate. I mean, I have not introduced a bill that I serve on the board of directors that would directly benefit that organization. And if I did, I'm almost certain that I would have, in my remarks, mentioned it. But that is the challenge that I'm having. I don't think that anyone did anything on purpose. You had mentioned that these complaints are here to punish Senator Champion. I don't think that's the case. I think what we're talking about is, should we, as members of the legislature, disclose very narrow situations where we're involved with an organization that might directly benefit that organization? And that has nothing to do with Rule 56.4. It might. If you have a financial interest, then you, of course, have to disclose that. But I think there are certain situations that we can all learn from, Madam Chair, from this situation where we probably do need to disclose that information. And even if it's something as simple as in your opening remarks when you're presenting that bill, just so we don't betray the public trust.
Senator Miller, I think we're getting into discussion here, which is fine. I've been holding my comments back.
There might have been a method to my madness.
I have a lot of, yes, to move us along, I have a lot of comments. And just wanted to say something briefly to you and why this does concern me. I agree with you that I probably would do the same thing. I would proudly announce my connections to this organization. But what if I forgot? I mean, what if I'm introducing a bill to help an organization in my district and, oh, I actually served on the board 30 years ago. You know, I've been around this place a long time. And maybe I forgot to mention that because it was so long ago. So it's just, I'm not a current board member. I was a previous board member. It's why I'm nervous about how far we're going to go with this and why I made my comments earlier about our advisory opinion, that we just have to move cautiously. And I think that we had discussed the potential offline of referring this issue to the Rules Committee, and it may be something that the Rules Committee, when they look at writing broader rules around ethical conduct, as is brought up by Senator Champion, Mr. Zoll, and others, needs to take a broader look at this. But bringing us back to any more questions for Mr. Champion or his attorneys?
And Madam Chair,
it looks
if I
like
could
Senator
just
Champion
briefly,
wants a
this would be
respond.
very brief, that I'd just like to, comment on what Senator Miller said. So two things. One is, I believe that there's always room for improvement. I always believe that we can learn from every situation. I think this is one of those moments even for us as a legislature. But the danger that I don't want us to forget when we glean things from an article and assume that those things are true is that the information sometimes is untrue. When you think in terms of, as I just look at all the articles that have been written, they have made various mistakes. Like, for an example, they tried to conflate the fact that I carried a bill for an organization, a nonprofit, which is a 48-year organization for chemical dependency. That's in my district. I went to their facility because I go over there and sometimes speak to the men and other folks who are struggling with chemical dependency. They showed me how their building was falling apart. I said, hey, we should bring a capital investment bill in order to get you some resources. Did that, asked for $2 million, got $1 million, and then that concluded in May, and then in November, by November, the very thing I was afraid of happened where their ceiling fell on a client. They were presented with a lawsuit. They were on like the 17th, 18th day of when they needed to respond. They called me, asked me if I would step in and help, at least preserve their right because they had some staff changes. I did so for a brief period of time and asked them if they had insurance and if they could file a claim, and then asked the insurance company to represent them. They did those things, and the insurance company did represent them. But in the paper, they made the connection of Senator Champion representing another client. Not that I stepped in order to help. Here's the last example that I give you. In the same articles, they mentioned in 2014 that there was another event in order to help, or at least a bill proposal to deal with community violence in our community. And that coalition brought something forward. And then in that same year of May of 2014, whatever happened there. But then in July, one of the individuals was assaulted, unfortunately, by the police, and there was a lawsuit. But the same article then said, this was a former client of mine where this person did not become a client for a brief period of time until after the legislation was done. So when you're listening to a variety of different things that are piecemeal from an article, and they're trying to come up with this pattern, it puts us in this unfortunate place of space. So thank you for your patience. I just wanted to say that because I do believe that when we talk about the public's trust, media can shape the public's trust that has nothing to do with what I did as an individual.
Are we ready to wrap up questions? Then we have 5-minute closing statement from Senator Kroon. I'd like to at least conclude this portion of our hearing before the floor session, and then I'm afraid we're going to have to come back after the floor session. Senator Kroon, do you want to do it from there, or do you want to go to the? You're fine there.
Thank you, Madam Chair. Can I ask one question before I get into my closing remarks?
Yes, Senator Kroon.
Thank you, Madam Chair. There was discussion about, serving on a board of directors and how you would proudly disclose that in the bill presentation. I understand that, but I think my question here is not just simply the fact that you were representing Salem Inc., but what that representation was about, I think, is relevant too. So my question is, do you think the fact that your client had recently been sued for defaulting on loan obligations would be a relevant factor for your colleagues in the Senate or to the public when deciding whether to support a bill which would appropriate $3 million of taxpayer money to that organization?
Mr. Zoll.
Chair Pappas and Senator Kroon, no. Because as Senator Champion explained, the funding that was being provided was for a new initiative. And it could only be passed from the state to Hennepin County to 21 Days of Peace if they carried out this new initiative. And with that funding structure, it does nothing to address the former financial difficulties that Salem Inc. found itself in. And if I may just make one final point, it's this. If the takeaway here is that the rules should change, you do not make that rule change when addressing a complaint where a senator had no notice of what the new requirement was or an opportunity to comply with it. Fairness requires that any change to the disclosures ought to happen through the regular legislative process. The final thing I would note in response to Senator Kroon's question is, at the time that the bill was introduced, the mortgage foreclosure actions had all been resolved through settlement, and therefore immaterial to the ongoing financial viability of the organizations, which is completely separate from any of the funding that was provided through the state.
All right, thank you very much. And Senator Kroon, closing statement.
Would you like me to present it from here? Chair?
Senator Kroon, whichever you prefer. You're fine there, or they're vacating the
I'll just do it here.
table. That's fine.
Thank you, Madam Chair and members of the committee. Thank you again for taking the time today to consider this complaint. Senator Champion established an attorney-client relationship with a constituent and then carried legislation that would give that constituent a substantial financial benefit. Senator Champion tells us he didn't disclose the relationship because he wasn't paid for his legal services. Well, that is relevant to whether he had a conflict of interest pursuant to Rule 56.4. Receiving payment for his legal services is not required to violate 56.1 and 56.3. Other senators and the public did not have a complete picture of the situation relating to Senator Champion's bill. They didn't know about his legal representation of Salem Inc. They didn't know about the lawsuits against Salem Inc. And we heard that Senator Champion's attorney said he didn't think that was relevant. Well, I can assure you that many members of the Senate would find the financial dealings and the financial condition of a nonprofit who is about to receive $3 million of taxpayer money highly relevant. At a minimum, Senator Champion should have disclosed this information to give his colleagues a complete picture of the situation. And it's not clear whether Senator Champion could have disclosed that information without violating his obligations under the lawyer's professional rules of conduct, without written consent from that client to disclose not just the existence of the lawsuit, but facts relating to the lawsuit to answer members' questions that they might have had about this nonprofit that was about to receive substantial public funds. In my view, it would be virtually impossible for Senator Champion to disclose his attorney-client relationship with Salem Inc. without having to discuss matters that would negatively affect his client and bring to light some of the mortgage foreclosures and financial shortcomings that were recent of his client. It was an irreconcilable conflict between the two sides of Senator Champion's legislative and professional life. How could he have maintained an independence of judgment as a legislator when he was the lawyer for the group asking for public funds? That is impossible. And by failing to avoid actions that might impair his independence of judgment, Senator Champion violated Section 1.30 of the Code of Ethics. The fact that Senator Champion may not have had a financial interest in the legislation, the fact that he was the lawyer of the organization seeking the public funds could be perceived and has been perceived by the public that he might have had a financial interest, which is a violation of our Code of Ethics as interpreted by the advisory opinion in the Senator Shadhari matter. If Senator Champion wanted to carry this bill, he needed informed consent from his client to reveal information that may negatively affect them and then disclose it to his colleagues and to the public what he knew. Senator Champion's actions in this case fall short of what we should expect of legislators. Relevant information shouldn't be withheld from legislators. The public and other members of the Senate should have had full information about the legislation under consideration. And Senator Champion's stated position that because he felt he didn't have a conflict of interest, he didn't have to disclose anything, left the public and the Senate in the dark about information they likely would have found relevant in making a decision on whether to support the legislation. This betrays the public trust in violation of Senate Rule 56.3. This committee has already said they felt Senator Champion should have been more forthcoming. We are asking the committee to take what you've already decided to its logical conclusion and say that the failure to be more forthcoming rises to a violation of Senate Rules 56.1 and 56.3 and our Code of Ethics, and that the committee takes the appropriate steps in response to the violation as a result. As a previous Ethics Committee wrote, quote, senators should at all times conduct their legislative actions in an open, honest, forthright manner, especially when they may be perceived to have a financial or personal interest, unquote. Those words were true in 2010, and they are true today. Thank you for your time.
Thank you, members. We can take a few comments, and then we will recess for session and then come back after session to finish our deliberations. Anyone want to make a few? Senator Matthews, sounds like you're ready.
Thank you, Madam Chair. A lot of discussions made today throwing around the term slippery slope. And I feel that the respondents are asking this committee to adopt a slippery slope characteristic around situations like this. Their position is that a legislator can try to help authorize public funds and taxpayer dollars to a very special or close relationship, or to a former client or current client, and I don't think that that distinction even matters for this discussion, and that we can go ahead and just do it and not disclose it, and that's totally fine. And I think that standard needs to be arduously rejected, because whether good intentioned or not, I think that is a slippery slope to corruption. That legislators can come here and give out money to friends, to people with close relationships, that there are people that have an inside track at a legislator versus those that do not. And I think that only builds to the public perception of some form of corruption, of giving money in inappropriate manners to people with friendships or relationships or close distinctions. I think there's a lot of scenarios we can work through, like 30 years ago, and do we remember, and all of that. And I think there's work that needs to be done on that. But I think there's a lot of pull just to the financial aspect, and the respondents are basically saying this type of conduct should not even be considered a violation of Senate norms or betrayal of the public trust or bringing the Senate into dishonor and disrepute. And I would arduously reject that standard. I think even the notoriety that this case got is demonstrative of the fact that that is not an accepted norm of Senate behavior. No one can point to another senator that has come with a bill asking to fund a former or current legal client. I believe it does betray the public trust, because a lot of people bring into their mind, why are we funding organizations that we have close relationships and close perspectives and close interactions with? Why are we giving away taxpayer funds in such a manner? And I think it has brought a measure of dishonor here. So we need to get back on the rules that we have, and I don't think, regardless of what the outcome of this hearing is, we should absolutely not be accepting the standard that this type of behavior is suddenly okay under current norms, and believe that it's not any type of violation of public trust.
Thank you, Senator Matthew. I did want to make one comment about much of the complaint has to do with the Minnesota Rules of Professional Conduct. I noticed we have not had a lot of questions or discussion around that, and I think it's more proper that we do focus on 56.1 and 56.3 and the Senate Code of Ethics, because we're not a body or venue where we judge lawyers' behavior. That's not really appropriate for us. So I'm glad that the discussion has not dwelt too much on that issue. And then I think that that the whole issue of accepted norms of Senate behavior I think this has not been part of the accepted norms of Senate behavior. And if there were not disclosures made in the past, we don't know, because disclosures weren't made in the past. So there may have been similar incidences to this, probably not exactly this. But because we're a part-time legislature and we have a lot of professional duties and community duties outside of our part-time job, a lot of that, I think, is used to inform our work. That, for example, if you're a nurse, you may say, you know, I think that it's important that we pay attention to the ratios of nurses to patients, because in my experience, this has been an issue. If you're a real estate agent, maybe you've seen problems in your practice around the HOA situation, and so you work with the community to resolve those laws. If you're a malpractice lawyer, or you're some other kind of lawyer, or a criminal justice defense lawyer, which we have a number of them, maybe you see problems with our criminal justice system. And so that's a broader issue, and why I'm talking about a slippery slope. I understand we've been using that term quite a bit. I apologize for starting it. And some of those can impact your livelihood or not. You know, some may impact your reputation. Some may impact your relationships. There's just so many different incidences of that, which is why I think we have to be very clear, even when we say an appearance of conflict of interest is a little bit in the eye of the beholder, which I think we're seeing here today, is that some people in the media, or some people who are outside, or ethical people outside of this body, see a conflict of interest that's not really clearly defined or specified in our current rules. So, you know, similar to discussions we had earlier around the advisory opinion, I do think that, you know, we could make recommendations to the Rules Committee about looking into this more deeply. But in this case, I just don't see that we can hold Senator Champion to a standard that's not really clear enough in our own rules. Any other comments before we take our break? Senator Miller.
Thank you, Madam Chair. And the only thing I would say is, in everything that we're discussing, I mean, the rules are pretty clear that if something violates accepted norms of Senate behavior, or that betrays the public trust, or that tends to bring the Senate into dishonor or disrepute, I agree with your slippery slope terminology, that if you start to pinpoint every single situation, that would be difficult. But I also agree that it is the responsibility of us as members to know when to disclose something and when something doesn't need to be disclosed. And I would say, in your example, if you served on the board of directors for an organization 30 years ago, to me that would not be something that would need to be disclosed. But if I currently serve on the board of directors that I'm advocating they receive public funding, taxpayer funding, I think that should be disclosed. But part of this is on us as members of the Senate, personal responsibility. What should we disclose and what should we not disclose? And I'm not sure that the rules need to go into any more detail. I don't think Senator Champion should be punished for the work that he does in his community, as Mr. Zoll mentioned earlier today. But I do think that this is an opportunity for us all to learn from this experience and do better as members of the Senate.
Thank you for those comments. And with that, the committee is in recess until 30 minutes after session adjourns.